Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. With me is Judge Shin and Judge Englander, and together we are your panel for the special two-case sitting today. I want to remind folks that although this may seem like a private chat in some respects, it is quite public. We're streaming live and it is also being recorded. So ordinary rules of decorum, please apply. I want to assure everyone that we have read the briefs and are familiar with both the facts and the arguments. So we would encourage you to cut to the chase. 15 minutes is ordinarily not a great deal of time, so please keep that in mind. On the other hand, if you feel like you've made your main points, there is no shame in stopping. I would say sitting down, but it looks like you are sitting down. Now, with that, we're going to hear the first case. It is now 9:32 a.m. and our first case is Commonwealth versus Diaz-Arias, 19P 624. And because this is a Commonwealth appeal, we will hear first from Mr. O'Sullivan.
Good morning, and may it please the court, Shane O'Sullivan for the Commonwealth. The Commonwealth submits that the search warrant in this instance was supported by adequate probable cause, with or without the information obtained through the use of the ruse of the officer posing as an utility worker. However, we also contend that the ruse itself was proper in the circumstances, was an acceptable way for the officer to learn of the location of apartment 2R within the target building. In regards to probable cause determination, there's no bright line rule for this determination. The
Commonwealth argued below, counsel, that there was no expectation of privacy in the area from which the apartment was observed by the officer who was the National Grid uniform.
I don't know that we argued that below, Your Honor. I think I would concede that there is at least some expectation of privacy in the public areas of a large multi-unit apartment building.
There's case law that says a large multi-unit apartment building, there is no expectation of privacy, even if there's a locked door.
It certainly, I don't believe, rises to the level of inside the home, the unit itself.
In any event, you don't recall this argument being made below. Is that where the Commonwealth is?
I don't know that. Yeah, I don't know that argument was made below, or that there was a motion to reconsider to consider that aspect, Your Honor. I'm not aware of that. In any event, the probable cause determination that was made based on the facts in the affidavit, the Commonwealth would suggest made a clear determination of probable cause to enter that building, and specifically that unit. This was a detailed investigation. Multiple controlled buys were conducted that originated with the sellers coming from this apartment building. The Commonwealth argued that the utility bill alone provided a sufficient nexus to.
Do you have any cases that talk about a utility bill alone being sufficient?
Your Honor, I don't believe that the Commonwealth has cited any cases that a utility bill alone is sufficient. I also don't believe the parties have cited any cases that a utility bill alone is not enough. The argument I would make in regards to the utility bill is, I would ask the court to think about the importance of a utility bill. It would be unusual for someone to get a utility bill for a unit that they weren't going to pay for the electricity or gas or whatever it may be. Utility bills are used by persons to prove their residency when they go to get a license, when they register to vote. That's the reason why we use utility bills, is because it is good evidence of a person's residence somewhere. And this utility bill listed the defendant's name at apartment 2R specifically, listed a phone number, I believe, as well. And that same defendant was seen engaged in participating in at least 2 of the control buys. So even absent his observation in the apartment through the use of the ruse, the Commonwealth would suggest that a utility bill, when combined with other evidence, the other evidence of the drug distribution coming from the larger building itself, was a strong indication that apartment 2R was the location in question and provided an adequate nexus to support probable cause to search there.
Does the Commonwealth defend the ruse itself? If you assume that there was an expectation of privacy in the area to which he gained access, the Commonwealth defend the use of the National Grid uniform and the question, do you smell gas? Is that acceptable in order to gain access to an area in which let's assume there is an expectation of privacy?
We would defend it under the facts of this case, Your Honor, and I certainly could see a situation where maybe that type of a ruse would not be acceptable. But the first preliminary point I'd make on that is the judge below relied on the Geraldo case, the federal case from New York. I believe this case is somewhat factually different. That case, they say that the ruse was that the officer stated they were, quote, checking for a gas leak. So in this case, at least they didn't go so far as to suggest that there was an actual leak.
It's a reasonable inference, isn't it? When the guy's wearing a National Grid, they don't usually wander around my house and ask if I smell gas unless they have some reason to be there.
Well, I think certainly they probably carry out some administrative tasks or check and do maintenance. And furthermore, the National Grid employee or the police officer posing as the National Grid employee in this case, he didn't make any claim of authority to enter. He was invited in after simply asking the question, hey, have you smelled any gas? And he's invited in without
raising the fear of an explosion. He was invited in.
Well, I think that, the question in consent is obviously, was it mere acquiescence to a show of authority? And in this case, I would argue there was no real show of authority. I'd also note that the stage of the investigation at this point, it was clear from the Commonwealth's reading of the affidavit that based on—
Does it have to be a show of authority, or can it simply be an act which vitiates consent?
I would suggest it has to be some show of authority, some request or demand that to be an acquiescence to a show of authority. I would suggest that a show of authority must first exist. But even getting beyond that, at this stage of the investigation, it's clear from the Commonwealth's reading of the affidavit that at the very least there was probable cause to get into the building, and the Commonwealth suggests there's probable cause to get in the apartment upon the discovery of the utility bill. But what the officer didn't have was, in essence, directions to get to that unit. And all that this ruse really uncovered was the kind of description of where apartment 2R was located. The officer stopped at the doorway, even though being invited in to the unit, I think, did a good thing and stopped at that point, said, no, he didn't, violate any rights of the defendant to enter his apartment using the ruse. He waited, held back. All they essentially gained was the detailed description, which you see cited in the Commonwealth's brief in the affidavit, of where that apartment's located. And why that's so important is to ensure that the officers, when executing this warrant, which can be sometimes done quickly under stressful circumstances, there's a potential for violence in these types of situations. I'm not suggesting that there was evidence that this particular defendant was of a violent nature, but anytime you're entering into someone's home, I think that's a possibility. I would suggest that's a real possibility. And so what the officers gained from this ruse was essentially the exact location and
I understand the point. I understand the point, counsel. I think we need to turn to the voluntariness issue unless.
Yeah, actually, before we do that, could you briefly address the connection between the apartment building and the controlled buys? Because the picture you paint in the brief is somewhat different from what the judge seemed to have concluded in terms of the direct temporal connection.
Sure. Yeah. The affidavit lays out these 8 controlled buys, and by the Commonwealth's count, it looks as though controlled buys 5, 6, and 7 all originated at 289 Hancock Street. Now, the defendant would suggest that the origination at 289 Hancock Street is somewhat diminished by the fact that the defendant or the co-defendant then stops at other locations along the way prior to the control buy. What the Commonwealth would point to is the officer who writes the affidavit, who's an experienced narcotics officer, states that based on the locations and durations of the stops, in his opinion, those the stops in between are consistent with drug distribution, and the Commonwealth thinks that's a fact that really should not be discounted by this court. Number one, he lays out through surveillance of the defendant, not in connection with the control buy, but later in the affidavit, there's dates of surveillance. Some of the reasons why the stops that the target is named Carlos are consistent with drug distribution. He talks about essentially or lays out essentially successive quick encounters in these different buildings. We know from the O'Day case cited by the defendant, which is a little bit different because it involves customers coming into a building rather than a seller going to customers. But they say that the numerous quick visits into a defendant's residence, if in the opinion of an officer is consistent with an experienced officer is consistent with drug distribution, is a fact that can be relied on. And they also state,
counsel, why don't we turn to the voluntariness issue now?
Okay, as far as the Miranda issue, I believe the facts presented are clear that Miranda was given prior to any.
Let's not call it a Miranda issue. Let's call it just a
voluntariness. Sure.
The government has a burden to prove it was voluntary beyond a reasonable doubt. The judge says you didn't prove it here. Are we
and I think that really.
That? I mean,
no, I don't believe so, because I would suggest that there's a determination of law that is made here. So voluntariness is a mixed question, but there's a legal conclusion that needs to be drawn. And for that, I would just point to, despite the threat that was, or whatever you want to call it, that was conveyed, what the Commonwealth characterizes as, a accurate expression of what could be joint liability in this type of a situation. The defendant was informed of his rights via Miranda. He was not intoxicated or confused. The judge credited the officer's testimony on these points. He was experienced with the criminal justice system.
Right. Do you have any cases that tell us what we do with the conclusion of a judge under these circumstances? I mean, I've read a handful this morning, and I don't see anybody telling us what we do with the finding, whether there's deference due, under what circumstances is there deference due, that the will was overborne, which sounds to me like a finding of fact. his will was overborne. But here we know really there was one statement, although it comes out in multiple ways between direct and cross-examination.
Well, Your Honor, I don't know that it qualifies as deference of a fact finding, and just, I would say, in a way, this is, his will was overborne. The finding was made about the defendant. It's not as if the defendant is an individual who testified, who the judge got to see firsthand. That the normal type of fact-finding deference, it's for that reason that the judge is in the courtroom watching this witness and making this determination.
Right, but he's making a decision about the will of the defendant being overborne based on the testimony of the officer who was in the room and actually made the statements that caused his will to be overborne in the view of the judge. I mean, he's got a witness there, right, who was present when it happened.
Yeah, that's correct. But the ultimate conclusion is the defendant's will being overborne, or that of a person in the defendant's shoes, and
but
the voluntariness.
What is it that you're asking us to decide, that in these factual circumstances, as a matter of law, the statements were voluntary? I mean, the case that you cite, I forget the name of it. There was a video, right? It was an interview, and we could watch the video and make our own determination of whether the statements were voluntary or not. So I'm a little perplexed what we're supposed to do in this case when we have a finding from the judge that his will was overborne, and we have nothing to view for ourselves.
I guess I would just circle back to voluntariness is ultimately a constitutional question. So I do believe there's a finding of law there that.
Yeah, but it's a question of fact whether someone's will has been overborne, and we have the issue that we're an appellate court, and if someone has by definition, a better vantage point than we do, because they see one of the witnesses. I mean, are there voluntariness cases where defendants actually testify and say, my will was overborne? I have to think back about that.
Yeah, I don't know of any cases that.
I mean, it usually comes from the context of either, a lot of times now we do have video, but it comes from context of the description of the interview by the police officers, or a report of it, or I guess there have to be cases going back a long time where the defendant testified and said, this is what happened. But it's an unusual case. There is one sentence basically, which gets, as I said, it has different iterations depending on whether the officer's on direct or cross-examination. And that's determined to be enough to overbear this person's will. I mean,
unless my colleagues have specific questions, I think we're going to have to leave it there. Hearing none, thank you very much.
Thank you.
We'll hear from the defendant.
Good morning, Your Honors. I apologize for my technical difficulties earlier and that I missed the first few minutes. The judge will properly suppress this evidence because there was no nexus to the apartment. The information about this apartment was obtained using an unconstitutional ruse, and there was a utility bill. In dealing with the ruse, as described in our brief, obviously police officers employ different ruses all the time. When it comes to this type of ruse, this officer used kind of a community emergency type of ruse. If a National Grid employee comes to your home and asks if you smell gas, the logical follow-up to that is that there must have been some report or they are investigating a potential gas leak. This obviously leaves the individual with little choice, little room.
But all the ruse got him was inside a common area.
That's correct, but well, let me rephrase that. Part of the building may have been common, but the judge didn't make a finding of fact whether the hallway leading to the apartment was a common area. And we maintain that it wasn't, because there were 2 locked doors the officer had to go through to get to the hallway in front of the defendant's apartment. And there is no universal rule that hallways are always common. But more importantly than that, I think, is that every citizen has a constitutional right to cooperate and provide information to police without a warrant, or to go on their way. There's no obligation for anyone to provide information or let them into a building. And that's—
But they have to have an expectation. Your argument depends, it seems to me, on the contention that getting into that space and learning where 4R was, or learning that 4R was the defendant's residence, was unconstitutional. And it's only unconstitutional if they had obtained that information from something in which he had an expectation of privacy, right?
Well, I believe that the individual did have an expectation of privacy in determining whether or not he would consent to assist the police. So when he's guiding this officer through the building, he didn't have a choice whether or not to do that, because he was placed in the position of saying, oh, this building might blow up, or I'll let this guy in and I'll help him out in his investigation. I'll show him around, I'll give him the layout, I'll show him where the apartment is. All of that, he didn't need to do that. He could have consented to do that. He has a right not to aid the police. And that right was—
It's almost an argument that there's like a Fourth Amendment. It's an unreasonable seizure of the statements.
In some ways, yeah. And I think
Are there any cases that talk about it in that form?
Well, I think at its core, it's almost akin to maybe like a Terry issue where, an officer confronts someone on the sidewalk. That person is free to leave if the officer doesn't have a warrant or some other exception that the courts have recognized. And none of that existed here. This man was confronted by someone intimating that there was an emergency and offered his, help. It kind of exploited his, civic responsibility. I think some of the cases use that language. And that's dangerous. That's dangerous under the Fourth Amendment. It's also dangerous public policy wise, because people are going to be,
yeah, but it has to fit within some established Fourth Amendment doctrine. It's a very interesting argument, counsel. Let's—
Why isn't the utility bill enough when you couple that with the links between the defendant and Carlos, the links between Carlos and the apartment building? We don't need proof beyond a reasonable doubt here. We're looking at probable cause. In this context, why isn't the utility bill enough?
Well, anybody can pay for utilities. People can pay for utilities for family members. It does not establish residency alone, I would argue. In addition, the nexus is lacking because there's no substantial basis to conclude that anything will be found in this building, let alone the apartment. We have some surveillance, GPS and otherwise, that Carlos leaves Lawrence in the morning. He comes to 289 Hancock for a bit, and then he leaves. Now, the judge found that a lot of
he leaves and then he goes out and he meets with a bunch of drug dealers. And we know that multiple times when he leaves, he winds up going to a controlled buy.
So
you're telling us there's not a reasonable inference for purposes of probable cause that he's obtaining the drugs, or that there's something related to the drugs in whatever building in that building?
I don't think it's enough, because the routes that he goes, the places that he visits in the greater Boston area, the judge found, and in the affidavit, that these were kind of conclusory statements. There's no hard proof of what he was doing. And
of course there is. There are 8 controlled buys.
Well, then you get to the controlled buys, and in the controlled buys, there's no direct link to the building. The control. So
are you saying that on none of the controlled buys did he either go to 489 before or after?
No. So I'm saying by—
Okay, so why isn't that a link to the building when they've been observing him for months? I'm sorry, I don't mean to. I want to come back to the question that Judge Milkey asked, which is, why isn't why isn't the utility bill enough to connect him to that apartment?
Well, it may prove that he has some relationship to somebody in that apartment or some relationship to it, but it does not do enough to show a nexus between this alleged drug enterprise. And part of that is the controlled buys. So in addition, when they're not witnessing these supposed drug deals, they do 8 controlled buys to try to establish a nexus. Now on buys 5, 6, and 7, at some point during the day, Carlos is seen entering 289, excuse me, and then he goes around wherever he goes. And then at some point during that day, he goes to the controlled buys. There is not an allegation
He doesn't just drive around. He goes to known drug locations, and those locations are specified in the affidavit, where he spends 1 minute, he goes in without carrying anything and then comes out.
Right. So I would argue, and as the judge found, that a lot of those are conclusory statements, but importantly, there's no direct link to the apartment. The apartment is supposedly where they're getting, where there's drugs stored. He goes to the controlled buys without first going back to the apartment and leaving again. There's no direct route, like for instance, in Escalera, where the
apartment or the building?
The building, even the building, excuse me, the building, let alone the apartment. It's not a case where the informant calls the drug dealer. The drug dealer is seen going to this location, then leaving and traveling directly to the buy. There's multiple intermediary locations here. He's in his car. He's gone to this mini mart, which is also the subject of warrants. So there's no direct link. And in terms of returning, Carlos never returns back to this building, except for one instance where he drives to the building, picks up Mr. Diaz, and they go on their way. He does not re-enter the building, let alone the apartment. So there's really no nexus, no substantial basis to believe that this is somehow a stash house. At best, it's a residence. And the case law is clear that that does not mean that, drugs will be found there. So we believe that the judge properly concluded that, and that the information obtained via the unconstitutional ruse should not have calculated into the probable cause. And without it, there is, and even with it, there's no substantial basis to believe that drugs will be found in the apartment.
So can we turn, unless Judge Milkey or Judge Shin have a question about that, can we turn to voluntariness?
Sure, absolutely.
Why can't an officer say to a suspect, in words or substance, look, you need to talk to me. There are other people who are going to be in trouble if you don't?
I think that what the officer said was a little bit different, and I think the context matters. Because this is a totality of the circumstances determination, in looking at exactly what transpired here, he said that the officer said that, and the judge found that he said this woman, the defendant's wife, would be liable if he didn't get with the program and start talking. Now, this is where the defendant is seated next to his wife with their infant child on his wife's lap, surrounded by 6 to 7 officers who had just barged in unexpectedly to execute a warrant. And in this situation, being told this woman's will be responsible as well, it is psychological coercion. I mean, to threaten someone's loved one can be a form of that, and especially here with the physical proximity to his baby and his baby's mother, and the fact that they're both going to get carted off unless he speaks, is a little bit different than some circumstances where an officer may inform someone, look, other people may.
So if the wife and baby had not been next to him, it would have been okay, but because they were next to him, there was more psychological coercion?
I wouldn't necessarily go so far as to say it would be okay, but I would agree that there was more psychological coercion here, and under the totality of circumstances, given that physical proximity, his will was overborne more to such an extent.
Counsel, did the judge actually find that his will was overborne?
I believe so. I believe he did, and I understand the Commonwealth's argument about the amalgamation of issues here, but I believe he did find that the statement was not voluntary because his will was overborne. I can reference the decision right now.
The last line of the decision, or the last line before he addresses the last issue. He does say it was overborne. I find that his will was overborne.
Right, and we would also argue that this, as you were asking counsel before regarding what the reviewing court would do with this kind of determination. And reviewing a motion to suppress, as you know, the court will accept the judge's subsidiary findings of facts, absent clear error. And here that I believe this is a question.
That's the general law, but do you have anything in connection with voluntariness, counsel? Because as I said to your brother, I took a look at a half a dozen cases this morning and did not really see anybody addressing in the voluntariness context where the line is drawn between subsidiary fact finding and ultimate conclusions.
I don't have a case exactly dealing with that issue, but because it's a totality of circumstances determination, I think that deference should be given to the judge in that regard.
So your answer is because, so it might be okay in some context to say in words or substance, you need to talk to us because if you don't, someone else is going to get in trouble. And you don't want them to get in trouble. That might be okay in some context, but not when it's your wife and she's sitting next to you. I mean, it seems to me, I'm not someone who's done a lot of police investigations in their life, but it seems to me that the kind of statement that says, you need to talk to us because there are other people who are going to get in trouble is something that gets said a lot. And when someone talks, it's automatically involuntary?
I don't think it's automatic, Your Honor. I think that the totality of circumstances includes looking at the whole setting. And here, the moment the police had just arrived minutes earlier, but 6 to 7 officers surrounding this man in his home with his baby and his wife, I think is a lot different than somebody in the interrogation room who has, been arrested and is, removed from there and it's a little bit different.
The guy's been fully Mirandized.
Mhm.
He has experience, right? There's evidence in the record that he has experience with the criminal justice system. So it's not like they barged in and screamed at him. They gave him his Miranda, sat him down.
Didn't the judge overstate things when he said that there was no evidence of the wife's involvement? I mean, if drugs are being stashed at their joint house, isn't that at least some evidence?
I don't believe so, because I believe in the transcript he asked the ADA whether or not they had any evidence against her, and she said that they didn't. I believe that's in the transcript.
Well, any direct evidence against her, but if they've got evidence that there's drug dealing out of the apartment, and then it turns out that she's in it.
Right, and I think that.
I mean, we have lots of cases where this is, where there's a spouse who is implicated because of their presence in an area where drug dealing is fairly regularly conducted.
I think that, so the officer's statement that she would be liable if he didn't start talking or cooperating was incorrect, because it didn't depend on him cooperating or talking to them at that moment, whether or not she would be liable. So, and also he didn't say she may be.
It may have actually been accurate. I bet she wasn't charged.
And I'd also just like to show that there was a temporal relationship here between that. So there is indication that his will was overborne, because he initially said, I'm not talking to you. And then they made the statement and immediately he starts talking.
That's what they and in Monroe, that was one of the things that they relied upon.
Yes.
Okay, unless my colleagues have a specific question, I think we're going to have to leave it there. Seeing none, thank you very much, counsel.
Thank you.
Very interesting case, which is now submitted. And we're going to take a brief pause while the session clerk changes out the cast of characters. Thank you very much.
Thank you.
I think we have everyone here. Can I first just do a sound check and make sure that council can hear us?
Good morning.
I can hear you.
Excellent. We are here on our second matter, which is 2018 P 1591, Commonwealth versus Morera. You did not hear my little speech, but you're both YouTube and it is also being recorded. With that, I will turn this over to Mr. Smith.
Thank you very much and good morning. May it please the court, I represent Mr. Morera in this matter. The Commonwealth repeatedly in their brief discusses the idea, sort of the proximity, the fact that my client was present. Sort of the biggest problem with that as a threshold matter is he was present and so were three other people.
Excuse me. I really can't hear what he's saying.
I'm sorry. Can you hear better?
I'm muted by host. Now I'm unmuted. I can, maybe because I can't see your mouth, maybe that's why. But I really
Okay,
couldn't hear what you were
I
saying.
think, if I might, that his connection, this happens sometimes, is not as good as everyone's is. And so he's having some delays. And we're just going to have to work our way through it, I think, Judge Milkey, understanding that we're not going to pick up every single word.
Okay, Your Honor.
I'm
Thank
sorry,
you.
is that better?
I can hear you.
Okay. So the Commonwealth is discussing this essentially as the fact that he was present, and they're saying there was some sort of proximity to the substance or to the staircase downstairs. The problem is there were three other people. I mean, that's just one problem, but there were three other people who were present. Perhaps the strongest evidence for the Commonwealth in this case might be the statement that he made. And the statement that he made to the officer up in the kitchen took place after the police had arrested him, after they had cuffed him, after they had him on the floor and searched him, and then after they brought him up the stairs, and not only one, but there were two police officers who escorted him up the stairs. One was in front of him and one was behind him. And then on top of that, he was sitting with that officer for some 20 minutes, I believe the testimony was, while the officer and he talked. So I would suggest, combined with the fact that there were multiple other people still in the basement going upstairs, downstairs at the time, I mean, that statement where he said essentially about one of the other gentlemen who was present, you know, he had nothing to do with this. Well, beyond that, it's simply consistent with him having been there when the police raided the house. And even if it shows at most, I'm not conceding this, but even if it shows at most, all it would show is that he had knowledge of what had transpired. That was it.
Well, wait a second. And I'm struck by, and there's a punchline to the question, but there are scales in plain view in the basement where he's found. There are baggies in plain view in the basement where he's found. There are drugs that are not within reach, but a jury could infer that they had been thrown to the spot that they are. All of those, it seems to me, give rise to an inference that a jury could find beyond a reasonable doubt that someone in that basement was engaged in drug dealing, and that all four of the people in that basement knew it. Do you agree with that?
Well, there's four people. Even if they all knew it, even if my client knew it, doesn't make them guilty. They would still have to, the Commonwealth still had to prove that he had the intent and the ability to exercise dominion and control over A, any of the drugs that were in there, and B, a firearm as well. And that's the problem here, that the Commonwealth had no such evidence that would suffice under the case law. The case law is very clear. What you just outlined, Your Honor, there's case after case that says, sure, that may very well be enough to constitute knowledge.
Well, there's also evidence that he lives there.
There was evidence that he had stayed there sporadically, according to the owner of the premises. There was no evidence.
I
that
don't know
would-
if the word was sporadically, but maybe not all the time.
Correct, correct. And there was evidence, and the judge outlined, I'd like to read in that regard, the judge had
And isn't
outlined
he
that.
the only one of the four? So there are four people in the basement at the time, right? He's the only one as to which there's evidence that he stayed there.
No, that's not correct, Your Honor. The testimony was there were multiple people who had stayed in the basement at various times.
But among the four people who were found in that basement, Vieira, I can't remember all the names, Duramo, him and one other, he's the only one as to which there was evidence that he had stayed in the basement. Am I right?
That could be. But again, there were four people there in the basement. The fact that he stayed there sporadically and other people did as well is completely consistent with he was there from time to time. And that
But
he
the
made
fact
very,
that other people had stayed there at other times, I think, isn't particularly important. You have drug paraphernalia in the basement, you have drugs in the basement, and you have four people, one of whom had been staying in the basement. As you say, the evidence is not continuously, but he had been staying there. It
Right.
just sounds to me like if he's the only one there, then there's enough evidence, but lucky him, there's other people in the basement at the same time. That seems to me to be a rather unusual way to go about analyzing the sufficiency of the evidence.
well, I mean, respectfully, one would have to sort of conclude, well, he's guilty, they were all guilty, unlucky for him, there's other people. I guess, I don't think we can really look at it that way. With all due respect, I don't think that's the proper way to look at it. I mean, the fact of the matter is, even accepting everything that you just said, Your Honor, it still doesn't get us to the other prong, which is his intent and his ability to exercise dominion and control over the substance. That's nothing. And the Commonwealth is
Well,
relying.
if it was his room, then there is case law that gets you dominion and control.
Sure. Or for instance, if there had been receipts found in, right there next to the drugs, next to the paraphernalia, next to the gun, utility receipts, something like that, sure, totally different case. I'm not disputing that. But there was none of that here. And so you had that statement, and then you had him being taken up the stairs. And he's taken up the stairs in the context of everything I outlined, which respectfully, I would suggest even taking the evidence in the light most favorable to the Commonwealth simply is not a sufficient inference that he had the ability and the intent to exercise dominion and control over the substance. There was also evidence as well that there had been a curtain sort of in front of or around that whole stairway section, combined with the fact that in that stairway section there were clothes, maybe other items, and that the substance was found on top of that. Gun was in fact found secreted behind that. Now you mentioned, Your Honor, about that the jury could infer that people threw things. I really wouldn't concede that. There really was no evidence of that. Maybe it's consistent with it, but
It's just an inference, right?
I don't think it's a fair inference. I really don't. I think it's conjecture. I mean,
that drugs worth $4,000 were just left sitting on top of a pile of clothes.
but again, there was nothing tying my client to having had dominion and control over that. It was extremely.
I thought we were just talking about the inference that the drugs had been thrown there. Can I ask, what about the drugs found on the stairwell?
Correct.
I mean,
correct.
we do have this one officer who says, I went up behind him. There was nothing on the stairway. I came back down. There were these, I found them on the stairway. I don't believe anyone else had been up and down the stairs.
Right. Well, he really didn't know. Combined with the fact my client's handcuffed, he's arrested, he's put on the floor, he's searched, he's brought up. There's one officer in front of him, there's one officer behind him. They also testified they saw nothing at that time. And then 20 minutes transpire. So under normal circumstances, and certainly.
Where do I find the testimony that when he was arrested, he was put on the floor, handcuffed, and searched before he was brought up the stairs?
I cited that in my brief, and I apologize I can't hear. I believe
It's all right. I can look it up.
I'm sorry. I believe it was volume 3, around page 13 through 14. I could be mistaken, but I think it's in proximity to that. And
Do you remember what officer so testified?
I didn't write. Might have been Trooper. I'm not entirely sure on that.
Okay, well, we can look it up. Thank you.
Thank you. So again, had it been the case that he was, certainly if he was the only person in that basement, they bring him up. I still think it strains credibility at best, but of course I would concede that the Lattimore standard doesn't take that into account. But regardless, here just talking about the fair inferences, the fact that they say they find these, a police officer also testified, and I think it's rather remarkable that he never documented that in his police report, that he finds these substances. But again, I'm not suggesting that alone gets me, over the hurdle here, or however you want to look at it. But in any event,
was there any evidence tying the drugs found on the stairs to the drugs found under the stairwell, such as similar manner of packaging or anything of that sort?
I mean, to my recollection, no, Your Honor. I stand corrected if that's not the case, but to my recollection, no, there was not.
I'm sorry, I didn't hear that answer.
I'm sorry, to my recollection, Your Honor, no, there was not. And there certainly was evidence as well that even if the substances were not in plain sight, as I think Justice Englander alluded to earlier, there was evidence about the bags. There was evidence about cut bags being on a table, but even that, it said they were inside of another bag and it was not readily visible from the outside. Again, even if that gets us over the hurdle, get the Commonwealth over the hurdle with respect to knowledge, the other element is simply not present. There's simply nothing tying my client in terms of the intent and the ability to exercise dominion.
So it wasn't clear to me whether the scales were in plain view or not. I believe the testimony was they were found in the TV stand. Is there any evidence that they were in plain view, or was it behind?
I don't see that. The evidence was they were present. There was some sort of a TV stand or a coffee table or something of that nature, or there was a coffee table plus a stand. I don't recall there being any evidence that they were in plain view. So beyond that, then you have the statement about that Mr. Frere, quote, has nothing to do with this. Again, it's the police raid the house. My client is present there. He may very well have known on these. I'd say it's a fair inference. He knew what was going on, that these people were dealing drugs. It would be a fair inference in that regard. And he's simply saying to the officer, look, you've got him arrested, this younger guy, I believe he was younger. You've got him arrested. He has nothing to do with it. That doesn't, in the context of all the evidence in this case, that does not get over the Commonwealth over the hurdle with respect to the ability and intent to exercise and control in this case. I would suggest that those two pieces of evidence we just discussed, I mean, by far are the Commonwealth's strongest sort of separate pieces of evidence that could otherwise have gotten them over the hurdle, but in this case, they did not. If there are no further questions.
I just point out that on page 225, Officer Costello, who found the bags and the scales, was asked, was there anything obscuring your view or impeding your ability to get those items from the TV stand? Answer, no. Right. Seems to me that's testimony that it's in plain view, nothing that suggests otherwise.
I would not concede that, frankly, on most facts, but again, for the sake of argument, I'll concede it. Plain as day. Let's say it's out there plain as day. Again, there's nothing unique tying him whatsoever to that. There's nothing that creates nothing of an inference other than that he may have been knowledgeable about it. Zero, nothing. And that is not enough for the Commonwealth, and the case law is very clear, as I outlined in my brief. I mean, there are multiple reported cases and unreported cases of similar type situations, and this court in this case felt, well, it's may very well be enough for knowledge, but it's not enough for the other required element with respect to construction.
Unless my colleagues have any more questions, I think we will leave it there.
Thank you.
Thank you very much. We'll hear from the Commonwealth.
Good morning, Your Honors. Audrey Anderson for the Commonwealth, if it pleases the court. The trial judge properly denied the defendant's motion for required finding not guilty, where the Commonwealth's evidence was sufficient to allow the jury to find the defendant guilty of all charges, including possession and intent to traffic the heroin and possession of the handgun found in the basement of the home, where the owner of the home agreed he could stay, and the defendant made statements to the trooper that another person in the basement was a good kid and had nothing to do with this.
Could we focus on the firearm for the moment? Unlike the drugs, the firearm is kind of at least semi-secreted away. What gets you proof beyond a reasonable doubt that he possessed that firearm and intended to control it? Knew it and intended to control it?
Because of the firearm's proximity to the drugs, it wasn't that secreted away. The officer didn't have to move anything to get the drugs or to get the 9mm or the magazine. The drugs were like right on top, and the 9mm and the magazine were on the side.
So, counsel, that the difficulty with arguing it that way is it's not really consistent with the argument that the prosecutor made at trial. At trial, the prosecutor made the argument that the drugs likely were thrown there in order to show some kind of connection or knowledge to the people who were in the room at the time. If you then say, oh, the drugs and the gun were both secreted close to each other, that undermines, it seems to me, the inference that the prosecutor asked for, that the guys in the room knew about it.
I'm saying that the gun was thrown and the drugs were thrown.
The gun was placed in an area. Well, we don't know whether it was placed or what. You're right. We don't know how it got there, but it was not sitting on top of a stack of clothes. It was sort of down to the side between the wall and some boxes, right?
Yes, between the wall and whatever she kept in there. She said she kept extra things in that area, the owner of the house.
So what is the evidence that the defendant had knowledge of the gun?
Because basically the defendant lived there for a minimum of 2 months. He basically knew every nook and cranny of that basement. It was
There's no such evidence of that.
You can make an inference that he did. If you're living in it's not a huge basement. If you're living in a basement, you know where things are in the basement. I think that a reasonable inference can be made.
But the
reasonable
gun was
inference,
found.
is that enough to have a reasonable inference that he knew that the gun was there on that day with multiple other people in the room?
Yes, I think it is.
The gun was found, as I understand it, between the wall and a bunch of boxes. What's the proof that he would have known what was in that space?
It could be seen though. It wasn't hidden. It was seen. You could look down, you could see the gun. It wasn't something that was, oh, let me pull out this box and, oh, there's a gun behind the box. You could see the gun, just like you could see the drugs.
Well, but he had to move a curtain aside, is my understanding, to see the drugs. They were not in plain view from someone standing elsewhere in the room. That's my understanding. Am I wrong about that?
Well, my understanding was there was no curtain. It seemed as if there was testimony from different people. Someone said there may have been a curtain, and then another person said there was no curtain. And I think that's addressed in my brief.
Where is the evidence? Let's put it this way, counsel. Where is the evidence that someone standing in the room, not in the immediate area under the stairs, could see the gun?
I don't know if I'm following you, because they said there's 4 people in the room. If
No,
someone-
forgive me, I'm just saying, so I just read some testimony about the scale not being obscured, being over on the TV stand. We have the diagram, so you can see where that TV stand is. But I think one could infer that the digital scales were in plain view from someone just standing in the room. Where is the evidence with respect to the gun of where it could be seen from in the room?
Again, you'd have to infer that someone walking by could see the gun. I'm not saying that, or the Commonwealth isn't saying that no one else didn't see the gun, that the defendant was the only person that was aware that the gun was there. We're not saying that.
I understand that, but the question is sort of the opposite, which is, where is the basis for a jury to infer that someone who wasn't specifically looking in that particular area could see the gun?
I guess I'm not following you, because I don't understand where that would lead. I think anyone that was looking in that area could see the gun. I guess I'm not following you, Your Honor.
I'm just trying to ask, I'm just looking for the evidence as to where it was visible from. Okay, I understand your point.
I mean, it's hard with the stairway, with the boxes and things, but I think anyone could have seen the gun. But
I don't recall reading that in the briefs. I don't recall seeing that in the evidence that I've read. That's why I'm asking the question. We can go back and take a look. Understand your point, Counsel.
Can we turn to the drugs on the stairs? How is it a reasonable inference that he dropped the drugs when, as I understand the evidence, he was handcuffed as he was led up the stairs?
He was handcuffed by Detective Mercurio, handcuffed him. Detective Dunn and Detective Wolf walked him up the stairs. Detective Dunn was behind him. How far the search went, I have no idea. I'm not a policeman.
But how do you drop drugs when you're handcuffed being led up the stairs?
They could have been in your mouth. I mean, I have no evidence of this, but they could have been in your mouth. They could have been in the cuff of your pants. You have one officer in front of you. Say I'm sandwiched in between them. I could have very easily dropped something out of my mouth. And Detective
Is your
Dunn,
brother correct that before he was led up the stairs, he was handcuffed and searched?
he was handcuffed. I'm not sure how that he was searched. I know the officer would have patted him down for drugs or for some type of weapon, but I'm not sure how much of a search went on, because they were saying they were securing the area.
Counsel, is it Detective Wolf? He testified that while the defendant was being interviewed upstairs, another person was also brought up the stairs, Chris Vieira, about 10 to 15 minutes after the defendant was brought up. So isn't it equally inferable that someone else dropped the drugs on the stairs?
Chris Vieira was one of the people that lived in the house. Is that what you're saying? Vieira was, or was he an officer?
That Detective Wolf, Officer Wolf, testified that about 10 to 15 minutes after the defendant was brought up the stairs handcuffed and was being interviewed in the kitchen, that another person, Chris Vieira, was also brought up the stairs. So how isn't it equally plausible or inferable that somebody else dropped the drug on the stairs if the defendant was not the only person brought up the stairs?
I didn't notice anything in the transcripts that between the time that Officer Dunn went back downstairs, that anyone else upstairs, because Officer Dunn testified that no one had come up the stairs.
Officer Dunn testified he believed nobody had, but Detective Wolf testified that another person was brought up the stairs. Assuming that to be true, would you agree that it's equally inferable that somebody else dropped the drug on the stairs?
Assuming it to be true, as another person could have dropped it. But there is also a Chris Vieira that is a police officer, maybe. So I'm trying to, that's why I asked the name. I'm not sure if you're saying there was an officer
No,
or.
not
if
an
there-
officer, the person who was staying off and on in the basement or who was. in-
Okay, I didn't read through that timeline that happened.
So if the evidence is insufficient to connect the defendant to the drugs that were found on the stairs, how do you connect him to the drugs that were found under the stairwell?
From what I've already talked about with the gun and living there, the renting of the rental car, using the rental car from someone else, the flip phone, which was a disposable phone that he had right next to him, his other phone that he had next to him, but basically his admissions. When he was handcuffed and brought upstairs by Officer Wolf, he said, "What is going to happen to Ivan Vieira?" And Officer Wolf's like, what do you mean? Why? What's going to happen to him? He's a good kid. He had nothing to do with this. Officer,
What is that an admission of?
That's an admission of he was involved with the drugs, that he knew what was going on, that he was involved with the drugs, and that Ivan Vieira was not involved with the drugs. To me, that's
The Commonwealth never argued this as a joint venture case. Is that correct?
as far as I know, no, they did not. Are there any other questions?
But just curious, what are we to make of the absence in the police report of the mention of the finding of the drugs? In a drug case, that seems like a fairly important omission.
I really didn't hear that, Your Honor. I'm sorry.
I said, what are we to make of the absence in the police report of the mention of finding the drugs?
I don't know, Your Honor, 'cause I really don't remember the police report. I'm sorry. I don't remember that. No finding of the drugs on the stairway, or no finding of the drugs on the on top of the clothes.
I'm not sure which, but either one seems
I think
pretty,
it's the ones on the stairway is the way I read the briefs.
yeah, but
They're not in the police report.
either way, it seems like a fairly important omission in a drug case.
Were there no drugs, or was there no pictures of the drugs? I remember there were no pictures of certain things.
I believe there was no mention of the drugs, but
I really don't remember that, Your Honor, and I don't know what to say about that, but I remember that there was a question about certain pictures of drugs. That was my recollection.
okay. Do my colleagues have any more questions? Seeing none, counsel, if you're prepared to rest, I think we have it.
Okay, the Commonwealth rests on its brief. Thank you very much, Your Honors.
Thank you all. I realize that the circumstances are not ideal, but we appreciate your participating in this manner. The case is now submitted.
Thank you.
Thank
Stay
you.
safe.